Well, if you're looking to have some fun with a probate attorney, the last words before I hit the let's go live button with our guest today was let's have some fun. I'm all for that. If you know me, when people ask me how long is the interview, I say, well, as long as I'm enjoying it, I'll do it. I assume if I'm not enjoying it, you're not, and listeners aren't. We're excited to have here today who you might normally think of a litigation attorney in the area of probate and trust to be a little dry, a little, I don't know, by the book. But no, not at all. Big smile, lots of fun. Really enjoyed talking to him in the past. I'm really excited to have him as our guest today, Nicholas Van Brunt, who is an attorney with, let me get the name right. I always feel like Groucho Marx making fun of law firms. Shepherd Mullen LLP, one of the largest firms, I think, in Los Angeles. Nicholas, thanks so much for joining us today.
Sure. Happy to be here. Good to see you again, Bill.
And so first off, you are, I think, Shepherd Mullen's one of the largest, one of the 5 or 10 largest law firms in general in Los Angeles, let alone probate. How long have you been with Shepherd Mullen, and what was it that got you into law in the first place?
Yeah, so I don't know the stats. I know we definitely have one of the largest LA offices in the city. I joined Shepherd Mullen in 2015, and I came over with Adam Streisand, who's my partner / mentor. We were both at Loeb and Loeb. Oh, look at me! Yeah, that's before I went on Weight Watchers.
You're looking guy in that photo, huh?
What's that?
You're looking guy in that photo.
yeah, exactly. It's like 30 years ago. No. So we were at Loeb and Loeb from 2006 to 2015, and then we came over to Shepherd.
Loeb and Loeb, also one of the largest firms, one of the largest offices in Los Angeles. And so really, most of the probate attorneys we've had on the show to date have been either sole practitioners or much smaller firms. And I think your specialty within the field of probate, trust administration, and litigation is the litigation side, and it probably takes a certain heft. So let's talk about how did you end up in the litigation piece of trust and estates?
So actually, when I started practicing, I worked more as a general civil litigator. I was at a third large law firm. That's where I started my career, called White and Case. I was there for a couple of years. I worked on the Enron litigation, among other sort of big ticket cases that were super interesting, but just at the end of the day, I wanted to get into court sooner. I mean, if I'm being really frank, and I didn't know that was going to happen for me anytime soon, where I was. And so that was one of the reasons anyway, that I answered a recruiter call after an all-nighter reviewing documents. And so that's how, and the recruiter was like, hey, Loeb and Loeb has this trust and estate litigation practice. I'm like, oh, dead people, that sounds horrible. I don't want to be involved in that. But, I went in the interview anyway, and I met with Adam and another partner there, David Nelson, who's still a good friend, and was intrigued, and then I met with more people and figured, oh, this is a good way to finish paying off my loans, and I'll get into court sooner. And I ended up loving it, So probate litigation, while you're dealing with the probate code and you're dealing with a specific set of cases that are the controlling authority in those matters, it's still civil litigation, right? It's still depositions. It's still going to trial. It's still discovery. It's still, arguing over motions in court. It's a lot of that stuff. But the stories are so much more personal to people, than your average commercial litigation matter, for example.
One of the things I think that real estate agents don't understand when they refer a case to an attorney is the importance of specialization. Now, my father was an attorney, but in the old days when you're more of a generalist, and that's all you really needed, kind of like doctors, now everything's more specialized. And to date, as I've interviewed probate attorneys, I've noticed there's 2 skills they have to master. There's the technical probate side or the estate planning side and the soft skills of communication. Right. In your case, you have to add in a third, which would be the civil litigation piece, right? You can't be great at probate and not really do well at the civil litigation. You're going to get wiped out. You can't just do civil litigation, not know the probate code, or you're going to get wiped out as well. So how do you balance those 2, and then third with some sort of personal skills with your clients and the emotions that go along with that?
Yeah, I mean, that's a really interesting question. So, first of all, in terms of just how you, bring the civil litigator, hat to also having those soft skills. I mean, any civil litigator has to do that to some extent, to be honest with you, because even if it's commercial litigation, it's still really important to your client, and you still need to know how to communicate and be an advisor to your client and then be an advocate in the courtroom. And sometimes what you're saying to your client under attorney-client privilege is going to be different than what you're saying in the courtroom when you're making an argument on their behalf, right? You're not going to put the worst facts that you're aware of that may not have been disclosed yet, or you're going to put the best light, truthfully, of course, but like you're going to put the best light on things in court. So you have to, no matter what, you have to separate that. I think when it comes to probate, specifically, and I imagine this is the case in family law, divorce proceedings to some extent as well. You just have to understand that the people you're representing and also the people on the other side oftentimes are going through one of the roughest emotional periods of their lives, right? They've either lost a loved one, or the loved one is still alive but has lost their capacity, or similar situations like that. I mean, they're not their best selves, and so you have to try to be empathic. You have to be honest. You have to, you got to be truthful with them about what the best and worst case scenarios are for them and all of that. But you just have to, it's golden rule, I guess, treat others how you would want to be treated in that situation. So you just have to have that in mind. And, we all succeed and fail with that to some degree, but it is something I try to keep in mind.
And imagine that's why you're with a larger firm, and that you probably have team members that you can assign different tasks to. One probably is in charge of the client, one's probably more involved with the other attorney or the judge, or paperwork or something like that. There's ways you can divide up when necessary to focus on the best skills and the best process.
No, it gets case by case. Obviously, if you have a larger case, there's one, sort of, or two attorneys that's maybe going to be mainly the client-facing attorney. But it really depends. And it's actually really important, at least I think in our practice, to have attorneys who are versatile in that respect. So I personally want an associate who's working with me on a case to be able to be client-facing, to be able to feel comfortable, talking with the client, to be a human being with them, as well as having the nuts and bolts experience and training them in that respect. So it's, I don't know that we have it's not like a football team where it's like, your guard is doing one thing and your running back's doing something else, and then the quarterback. I mean, usually I'm the quarterback in my cases, right? But you want people who are able to step into that role, because also we get busy, right? So sometimes I'm in trial and I need to know that the people I'm working with can step in, and the clients are going to trust them, and they earn that, through experience and time.
One of the question I have, and I don't know you can answer it precisely, but just I'm interested in your flavor of this, is, as a real estate agent, I get involved with a family or a family member, and they begin the filing process. They begin what looks like an administration, and all of a sudden somebody makes a phone call, somebody sends an email. Next thing you know, there's objection filed, and the next thing you know, it's like full-scale warfare with an attorney, and it goes from a disaffected heir to litigation, sometimes pretty quickly, and that can just change the whole process. And I think the client often doesn't understand that the attorney you pick to do the administration up front may not be the right attorney to get you through. Do you have any kind of insight on where that tripwire spot is, or what clues to look for, or what somebody should be thinking about when they see those kind of clues that there's a storm brewing and that we may not have the right ship to get through it?
I mean, as soon as someone raises an issue with the transaction, right, and objects, or as soon as that happens, you should ask the lawyer that's representing you, hey, if this gets to litigation, are you in a position to handle that? A lot of times a good probate administration attorney will, when they get that email, will say, hey, I'm not a litigator, here's a litigator I work with a lot, something like that. So, but if they don't do that, then you should ask the question sooner rather than later, because you just want to know. Maybe there are some really good lawyers that can do both out there. They exist,
There are, and I've interviewed some, and it's interesting how some will say, no, I'll never litigate, or no, I only litigate. There's that group.
Right.
There's another group that I've worked with that are good at both.
Mm-hmm.
And then there's another group that are only good or maybe average at administration, and will hang on to the litigation. I'm trying to say to the client, this person is not going to get you there. This is not the right attorney for this fight. And I'm always looking for ways to help them understand what they might be facing. You don't know how the objector, how to the mat they're willing to go. But, as an observer, oftentimes I say, this attorney is not asking the right questions. He's not preparing for war. Not to say you go to war and drop bombs, but you need to start preparing for war, I think, at some point, right?
Oh, for sure. Yeah. But I mean, I think that's in terms of like the inflection point. I found it. That's not the term you exactly used, but that, when you should start to ask that question, it's as soon as there is some sense of somebody's going to come in and object to this in probate court. As soon as that's a possibility, you want to make sure you have your ducks in the row for sure.
So in your case, again, you're a larger firm. What's kind of the typical size of estate that you're involved in litigation? Because there's obviously, even on modest estates, tremendous cost to
Yeah.
litigation. I tell customers as a rule of thumb, somebody's have to pay $100,000, $200,000 if it's going to go to hearings with discovery and objections. You need to be prepared to not run out of money, and then have to give up at some point halfway through that. And that's even what I would call fairly modest estates. What's a typical range? And I don't mean to give away any, industry secrets, but what's a typical range of an estate that you deal with, that you're dealing with litigation at a firm like yours?
So I've dealt with, and there are various business reasons why, okay, that maybe I won't get into, but there have been cases that have been estates that are 5 million or sometimes less, if it makes sense for other reasons, all the way to estates that, are the 9 figures or a billion. I mean, it's a wide range. Obviously, we're not the 99-cent store. So I mean, it doesn't make sense. And there's so many really good sole practitioners out there, or less expensive attorneys, where I will, if it really doesn't cost effective, then I'll be happy to refer, to. But yeah, we do a wide range, so that. But I would say that there's no particular sweet spot. It depends on a case by case basis whether we're going to be cost effective for it.
Got it. Real quick, just some housekeeping while we have a good opportunity. This is Probate Weekly. We do this every Thursday, 4 p.m. Pacific time, 7 p.m. Eastern. It's live stream on Facebook, YouTube, and LinkedIn. Feel free, if you're watching live, to put questions in. We'll try to get them here on the call. I see one comment right now. I'm a little late on. I'll get to that one shortly. But feel free to put your questions there in the chat box, and we'll get to those. And then if you're watching this on the replay, again, ask questions. Either I'll answer them or I'll forward them to Nicholas as appropriate, and we'll get back to you. And then you can continue the conversation on our Facebook group, Probate Weekly. We have 3,900 members, coming up on 4,000. And there, not only can you post your probate or trust-related content to get more views and likes and such, also looking for referrals out of state. If you're looking for a realtor and attorney in another state, great place to do that. This is really a national platform. I deal with real estate agents and attorneys across the country. I've interviewed attorneys in 20 states and have realtors across the country as well. So I'd love to have you participate. If you want to, and if you're watching this on replay and want to get reminders so you can come on live, go to probateweekly.com, put your email address and register. And then you also can scroll down and get past episodes on the audio version of your choice, or the past episodes on YouTube. Okay, so let's talk a bit about, I got a question here. Ann B, thanks for the question. You had an estate planning attorney say he's not insured for litigation. Yeah.
I wouldn't use that attorney for litigation then.
Well, I think the point is there are some attorneys who know they can't do it, and
Right.
and I respect that. Like it,
100%.
whatever your reason is, know your limitations and get somebody who can. And we've had some great attorneys on here who do litigate, you being one of them now, and some of the others in the past. And I don't think there's anything wrong with that if you know that. What you don't want is the one who thinks he can litigate or she can, and they're going to litigate. And I watch all the time, and they're just getting wiped out left and right, and it drags out for years. And
And the flip side is also true, right? So I don't personally do much trust administration. I mean, I will get involved in what's called, I would say, like adverse trust administration, where it's not quite litigation, but you're trying to resolve, a problem that's got an adversarial interest. And I'll certainly get involved in that because I do like problem solving more than anything else, to be honest. But if it's a full-on trust administration matter, then I mean, I'm not going to handle that myself. Now, we have a lot of attorneys who do that at our firm, and so that's more fortunate. So I can pass it off. And even smaller firms often are structured that way, right? Where there'll be somebody who handles trust administration, somebody who handles more of the litigation matters. You see a lot of that as well.
Yeah, and the ones that don't, if they're independent, they'll typically have a favorite attorney that does their litigation. They work together well. And I think that the handoff is better. And so in a case like yours with a firm, I imagine you're regularly either getting referrals from your administration department for litigation, or you're in litigation and they have a family member that needs administration that you're sending back. And that handoff is part of the value proposition that the same firm's handling our items, they have the file, there's some confidentiality advantages. And so that's part of the things that make sense there. So again, I don't want to get to, I don't want to compare to Amazon or to Zillow, but can you give me a range of what it costs to get into litigation? I think that some attorneys, they want all cash. Other ones will do it on contingency, but they need a certain amount of estates at issue. Is there, how do you advise somebody comes to you with a problem of a $5 million, let's say, estate? How do you advise them on what's going to cost them, and both upfront and over time?
This is going to be a very unsatisfying answer, but it's very case by case, right? So you could have a lot of different issues with a $5 million estate. It could be a contest over whether grandma had capacity or not to sign her estate plan, and you were a 50% beneficiary under one instrument, and then you're cut out of the next one. So that's worth $2.5 million to you. I mean, there may be other issues too, but let's just make it really simple. That may be worth $2.5 million to you. Well, how much is it going to cost? Well, let's see. You're going to have to get a medical expert. You're going to have to take depositions of maybe caregivers, doctors, maybe the accountant. So maybe you're going to have to take 10 depositions in the case. You have to do written discovery. You're going to have to, depose the opposing expert. I mean, and you have to say, okay, this is how many hours this is all going to take. This is how much we think this is going to cost if you take it to trial. This is how much we think it'll cost if you settle before trial. You try to lay that out if you can. It's really hard to predict litigation, but it's going to be six figures, almost certainly, right? And then it's a value proposition. Some firms obviously do contingency in this space. You have to be a little careful about that. There are some people that will, well, I'll give one example without attribution. Somebody was already a beneficiary, let's say, of a $50 million trust. And somebody said, hey, you should have control of that trust. I'm going to come in and help you get control. And I'm just going to take, 25% contingency. There's no reason that person needs to take $12.5 million. Right. So, so you have to be careful with that. But there are people who will do contingency work, and it's absolutely appropriate in some cases to do that. A lot of firms won't. We typically don't. I'm not saying we've never done it, but it's pretty rare. Usually it's by the hour, and then so it's like, okay, here's our billable rate, here's the amount of hours we think it'll take. That's kind of our estimate, right? And so
the most common area of friction in that discussion is people don't appreciate how expensive litigation, how expensive law is. And it's not just the lawyers getting paid. It's, even if you take that out, they have no idea the expense for you to get services done, whether it be paralegal services or transcripts or discovery or filing motions and things like that. It's just incredible. And I know that for those listening, it sounds, oh, gee, he's not answering the question. He's saying case by case. You're talking about an experienced litigator who's going to give you an assessment of the time involved in it. I think that's the part that we as professionals have to understand and prepare our customers for. It is very difficult to assess. And I'm sure, Nick, sometimes you make mistakes. You underestimate or overestimate a case, and look back on it, and the challenge is being accurate in that, right?
I'm actually perfect. I've never done it. Of course, everybody does. But and you can't. There's too much uncertainty to completely project. I will say that actually one of the issues that comes up is not just the cost. Obviously, the cost is can be eye popping, but
eye popping.
Yeah, like remember Who Framed Roger Rabbit? Like in his eyes. Yeah. But also there's the how do I put this? It's litigation takes a long time, right? Like the courts are really backed up, and it can sometimes. I have a case where a motion was filed and was set for December. Okay, like it was filed last month or whatever. That's 8 months.
And that's not bad. That's not really bad. I mean, it's
not bad.
I've seen worse.
I've seen worse, but then the trial doesn't get set. Your trial gets set 2 or 3 years after you've initially started the filing before you actually get to trial, right? And that's not uncommon. Now, there are some cases where you have priority, like a conservatorship theoretically should be sooner. There are cases where you're entitled to preference because somebody's older or whatever. But even then, it takes a long time and it's frustrating. And then hearings get continued because somebody's, gets sick or somebody's on vacation or the judge is dark this week or whatever, and it's really frustrating because here you are spending all this money just trying to get justice or to, defend yourself against claims or whatever. And it gets kicked out 3 months for something completely outside of your control. And it's really frustrating to clients. And I empathize with that a lot. It's also frustrating for us, who want to move things along. Believe it or not, like my goal when I get a case is to try to get it done as economically and efficiently as possible, but you only have so much control over that.
The common denominator I find of litigators, successful litigators, is they're tough, right? Because you deal with constant frustration, constant delay, constant challenges. And so, okay, a couple quick questions we have in the chat box. Thank you. Matthew Price is a regular in our call. He had a litigation attorney claimed to be an estate attorney and didn't know simple property ownership law. Now, Matthew's out of state. I think he's in North Carolina, if I remember. But those principles are the same, which is if you're going to do estate planning, whether you're litigating it or doing steps, they need to cross over to other fields, right? Like real estate law, family law. I noticed in your bio that you kind of have some crossovers as a result of your litigation experience, correct?
Right. Yeah, of course. Yeah, my head would hurt in that one too. I mean, you need to have, I don't know what the basic property ownership issue was, but yeah, you would expect that an estate attorney would have some basic understanding of real estate law. Yeah. Now you might not expect them to be a sophisticated real estate transactional person or to really be the person who's going to review a lease and understand all the conventions of that, but they should have a working knowledge for sure.
Well, and I would think that'd be the advantage of working at a large firm like yours, in that you may not have that expertise, but you can either walk down the hallway physically or virtually and get a partner or a colleague that's on the same team, and shortcuts that whole process to get some help, I would think, or bring them in if you need to bring them in.
That's definitely an advantage that we have, obviously. And then, but also for a sole practitioner, they should know somebody. If it's really important to know what you don't know and to be able to, and to be okay and to let your ego say, hey, I don't know the answer to that, but I know this person who does.
Right.
Because that's more valuable than pretending to know something that you don't know. So in the set, though your head hurt, if at least if he said, hey, I don't know simple property ownership law, that might be disappointing. Better than if he tries to, or she tries to, represent that they know something that they don't.
And to your point, the good litigators I know, they're at smaller firms, they're really networkers. That's probably why, because they need to bring in people into their specialties as well. So, and then Taylor Group, Ebby Holiday Realtors, thanks. First time watching. Curious how to get started as a realtor to assist clients go through probate. That's a great question offline. We're not going to, at the hourly rate of paying Nicholas for this call today.
This is a really good question for Bill Gross, if you want to ask. Yeah, Bill Gross.
Yeah, I'm perfectly glad. Down below is my contact info. Call, text, or email me. I'd be glad to share with you. And then last week's episode was free resources to build your probate business. I think that's a good place to start as well. So a couple questions more on litigation. What is the most commonly litigated issue or item or challenge that you are involved with? If you're to look back macro and say, this seems to be the largest or couple of largest issues, what are the ones that are the main issue that seems to be going on?
So the main issues, there's a couple, one is I've already referenced, which is the validity of an estate planning instrument, whether a will or a trust or something like that, whether the person who wrote it had the capacity to do it, whether they were unduly influenced into it, whether they're defrauded into doing it, that sort of thing. That'd be one bucket. The other sort of major bucket is fiduciary litigation, where somebody's a trustee or an executor and somebody's accused them of entering into transactions they shouldn't have, or stealing money or what have you. And so that's sort of the second main bucket. And then the third one that's really happened more and more, and it hasn't really decreased, to be honest with you, since Britney Spears, is conservatorship litigation. Litigation over who's going to take care of so-and-so given their lack of ability to manage their own affairs. I'd say those are the three main buckets. They're others, but those are the three.
So just to recap, capacity or validity of the instrument, the fiduciary is doing things properly or to the standards of the person, and the third you're saying is conservatorships?
I would say so. Yeah. I mean, I'd say in terms of what's occupying my time, those are the
Mhm.
three main buckets. Yeah.
So let's go back a little bit because we as realtors are kind of in the same space a little bit as far as the ability to sign a contract. And I've had the experience of going to a house where I talked to somebody and maybe in the morning they called me up and they sounded bright and alert and ready to go. And then you're there in the afternoon and they're just a little slow. Things seem odd. Things are piled up around the house. It was a little too easy to get the contract signed. So if you were to give, I mean, I know this isn't your legal advice, but you do see the litigation surrounding this. What are some best practices for somebody who's talking to an elderly person to avoid, or what are the warning signs maybe that you see people ignore or run through?
Yeah. I mean, that's a really good question. You know, so it's not that you have a duty to be a doctor. Like you don't have a duty to say, does this person have the legal capacity to enter into something? But and just because somebody does sign a document that maybe they shouldn't have, and it ends up in litigation, doesn't necessarily mean you did anything wrong because maybe you didn't know, right? But people, if you have a spidey sense, right, and you're like, this feels weird, slow down. Maybe say, hey, do you have an attorney? Hey, I want to have somebody else, look at this, or maybe we could schedule this for another time if somebody seems, if they're elderly. Because what you don't want to do is, I mean, at least in California, and I know that this isn't just a California, stream, but at least in California, I mean, the laws around financial elder abuse are pretty strong. And so, if you incur any sort of benefit by taking advantage of an elder, not only can you be liable for that, but you can be liable for the attorney's fees, if you lose. And and you can be liable for punitive damages potentially. So the risks are big. So if you're having misgivings, no transaction is worth it. No transaction is worth it. Even if you're going to win that case, no transaction is worth being sued, worth being deposed, even if you're not the party and you're just kind of involved. It's just not worth it. So I mean that's kind of my thought is just, or at least talk to an attorney, just hit the pause button.
One of the challenges of that is, and I'm sure you see the same thing, that I get called out to talk to somebody who maybe is elderly, maybe with one of the siblings, maybe the good sibling or the bad sibling, and then the other one calls you and tells you, no, that was the bad sibling, I'm the good sibling. And I feel like on one hand, my business is active enough where I want to just say, just run away from it. On the other hand, sometimes I would say, well, I want to help protect this person from the bad sibling. I don't want to make my life's work about it. I don't want my entire financial net worth on the line financially over it, but I
Right.
do want to be an advocate for somebody who might be the victim of elder abuse. So, again, what would you, I'm sure every case is specific. In a general sense, is that something where is it ever worth getting advice and backing yourself up, or is it just better to run and not be involved at all? Do you think?
Depends on the situation, obviously, but yeah, I mean, I would contact an attorney, in that situation,
Yeah.
because yeah, you don't. I mean, I'm a lawyer, therefore I'm risk averse by nature. Most lawyers are.
Right.
I'm less risk averse than some, but I'm still pretty risk averse. And um, you know, I can tell you that my regrets over the cases that I didn't take and that I see ended up making a lot of money are not as big as my regrets over the very few, but the cases that I've taken that I wish I hadn't taken. Right. And so,
Interesting.
yeah. And so to me, that's my risk tolerance and sort of my, sort of way that helps me, sleep at night,
Yeah.
but yeah, I mean, look, again, if you trust your common sense, if something feels weird, talk to somebody, talk to a lawyer, say, hey, this looks, and it depends on the situation and the state you're in, but there may be something you can do. Maybe, if you're really worried that someone's being subjected to elder abuse, maybe it's called adult protective services. I mean,
Mm.
there's things you can do in those situations, but I would get advice. You don't want to just go running hog wild. Talk to a lawyer that you trust in that situation.
And it's difficult. I was in such a case where clearly father was affected by the bad child. It was obvious to me that the deal he got into was bad, benefiting the bad child. The good child was overwhelmed because she went to an attorney. The attorney was overwhelmed, the wrong attorney. They'd spent time and money in litigation, and she was just ready to throw up her hands. And I think sometimes as a real estate agent, some of those cases you have to walk away from, and there's not much we can do other than, I think, educate people. And my goal is to get every customer can into an estate plan and into an appropriate plan to at least minimize those risks. Before I go to that topic, though, I'm going to finish up on the litigation. You mentioned the second area was fiduciaries, and as realtors, we get this a lot, right? Dad passed. My brother is the successor trustee, and he's not sharing information with me, or he wants to sell and I don't want to sell, or he doesn't want to sell and I want to sell. So what are the common issues you see in the fiduciary that are preventable, that somebody can plan ahead for when they do their plans, so they don't wind themselves up in that situation?
So are you talking from the fiduciary's perspective or from the perspective of the realtor? I'm sorry, I didn't fully understand that.
Sure. Well, I think that the customer calls me and says, it's too late. My brother's the bad guy, and he's the successor trustee, and he's not sharing any information with me. So I guess let me get a little bit more specific. What are the responsibilities of sharing information when you're an administrator with the people who would naturally seem to be heirs? And that's California law, and it's different in every state. But what are the responsibilities? I'm sure as a litigator, if they're not doing those things, you're using those things to invalidate them, remove them, suspend them, and such. So what are the requirements of a fiduciary in order to do the job by keeping all the other heirs or expected heirs informed of the process?
Yeah, no, great question. So in California, which of course what I can speak to, there's a duty to keep beneficiaries reasonably informed, right? What does that mean? Well, it means if there's a reasonable request for information, you're supposed to provide it. And if you don't provide it, and it's not provided within 60 days, then you can go to court and get them to provide it. Usually, there's also a requirement that accountings be provided, at least on an annual basis, for the trust. Now, sometimes the trust document, which is kind of like the constitution of a trust, right? It's a living, breathing document, but it'll say, I waive any accounting. Well, that doesn't mean you're not supposed to give any information. That's against California public policy. There's still some information that needs to be provided. If that information is not being provided, again, talk to a lawyer, because you're as a beneficiary, you're entitled, certainly in California, and it's different in some other states, the extent to which this is true, but I don't think there's any state, unless it's a very specific type of trust, where you're not entitled to any information about what's going on. So, and as on the flip side, if you're a trustee, so if you're like a trustee or an executor who's retaining bill to sell property, you're always better off in the eyes of the court. And just, generally, if somebody asks you for information who's entitled to it, you should provide them that information. You don't want to provide like attorney-client communications and stuff like that, unless there's a reason for it. But like, you should provide the information that's being requested if it's reasonably related to their interest in the trust or the estate.
Such as, do you plan to sell the house? Such as,
right.
Are you evicting the tenant who might be in there, or
right,
those kinds of things?
Now there could be, there's always exceptions, right? So there's, let's say the beneficiary happens to be the tenant in the house who you're planning on evicting, and who is causing damage to the other beneficiaries because they're not paying rent.
Common case.
Maybe maybe you don't need to. You still have duties to that beneficiary, by the way, and maybe before you file eviction proceedings, there should be some sort of negotiation or something like that. But or if you know that a beneficiary is stolen from the trust, yes. I mean, again, that's something where you want a lawyer involved, but you don't. So there's some common sense involved in that, but generally speaking, just for somebody who's just entitled to receive their portion of mom's, estate, just tell them what's going on, keep them reasonably informed. And by the way, and I saw somebody, there's an article that's coming out in the Trust and Estate Quarterly, which I know you're all subscribers to for California, but there's an article that I know is coming out where what somebody does is they really, literally, this is a good tip of the trade, they create a binder that just like keeps a log of what they've done, what they've informed the trustee, the beneficiaries of, etc. And the more sort of competent and organized you are and transparent you are, the better.
The most common case I get is a sibling, mom and dad pass. There's 2, 3, 4 siblings, and the one sibling in the parental home is the successor trustee.
Right.
Doesn't want to sell the property because he's living there for free.
Right.
If he sells it, gets split, 3 or 4 ways, but he's living there for free, getting all the benefit. To me, it almost seems like you're stealing from the estate by not managing it in a proper and timely manner. And that I always recommend them to go to an attorney to kind of force the issue that they'll need to do something. Is that a reasonable standard? And
yeah, it is. And now keep in mind, the trust may say, hey, my trustee gets to live in the house.
Right.
That's what I want.
But
ultimately, it doesn't matter what the beneficiaries want in that case, right?
Right.
I mean, within reason. It's what the person who established the trust said.
But they would have to disclose the trust that
Of course.
document that. So it's not like they can just say that. They'd have to provide to the beneficiary, this is the you're entitled to a core of the property subject to my living here for a life estate or something like that.
So any beneficiary in California, at least, and I think this is the case in various forms in other states, is entitled to a copy of the terms of the trust. First of all, they're supposed to get a notice within 60 days of somebody dying that a trust has become irrevocable, meaning it can't be changed, and that they have 120 days to contest it, and they're entitled to get a copy of the terms of the trust. And any beneficiary is supposed to get that notice, and any heir, even if they're not a beneficiary. So the difference between an heir and a beneficiary is that a beneficiary is somebody who actually concretely gets something under a trust or a will. An heir is somebody who would be the descendant if there was no will, through intestacy. So
that's important to remember. Now, that in and of itself, failure to notify in 60 days, in and of itself isn't grounds for removal, but it would be one step to say, hey, you started off on a bad foot, and then you didn't do this, and then you didn't do that, and you're building a case to perhaps remove them as the administrator in favor of some neutral person or other family member to do the job.
Totally. And it depends on the facts, right? If it's just like, if it's a family member who's like unsophisticated and just didn't know they were supposed to send out the notice, that's like one thing, right? And if they say, oh, I'm so sorry, here's a copy of the trust, probably not gonna be a big deal. If in fact they're, sophisticated and they just don't do it, or they're asked to do it and they refuse to do it, believe me, I've seen plenty of cases where like there's just a refusal to provide any information at the front end, like even a copy of the trust. Yeah, I mean, you're really starting on a bad foot there.
Okay, back to questions. I think you might know this one from Scotty G. Funk. Hey, Nick, from your experience, once a trustee or PR is suspended and an interim neutral is appointed, how often is that suspended PR reinstated, or does that neutral usually remain in place?
And now I'm wondering which Scott this is, because I have a case against a Scott right now with that exact fact pattern. So I'm gonna avoid that question.
Okay. Okay. And then answered by Matthew Price again, who's in another state of North Carolina, and he's saying once somebody's been suspended, they no longer come back. And I will say, not legal opinion, but my experience watching court cases, I used to go to court every day pre-COVID, that the judge, if they remove the person from being the trustee or administrator, if they go through that process, there's enough there. They're not going to like the person. They're just not likely to reapprove them to come back. I don't. There's a difference between that and a temporary or special administrator, right? Sometimes they can't agree, and while they're fighting, the judge will allow a special administrator for, like, let's say, selling one piece of property or selling a business. But in my experience on a human level, once the judge removes somebody, they're not likely to put them back unless they're forced to. I just don't see that happening.
Well, yeah, I mean, if they're actually fully removed, although I will tell you, go back to Scotty G. Funk's question, as I can say, absolutely it can be the case where someone's suspended but not removed. There's a resolution with the family and they're reinstated. Sure.
Yeah. I guess suspended versus if they're removed. I mean, I've seen cases have been removed because the fact pattern was they were misbehaving. That's a different level for the judge to do that. That's a big deal.
Yeah,
a judge is not going to be happy and likely to approve something. I get the sense, again, not legally, but just watching the judge's decisions and discussions, that they feel almost personally responsible for the administration of each of these cases. I don't think clients and families understand that they take their role very seriously. When they're approving somebody, it's almost like they're appointing somebody on their behalf to sign checks. And if the person doesn't do the job right, they're upset. I mean, I won't say take it personal. That's not professional, but it's almost as if they're taking it personal. So
Sure.
okay, and then that tripped off a whole ongoing discussion. I misraise play dirty. Yes, some do. And okay, so Matthew asked another question, which again, I think that's a North Carolina specific term.
Yeah.
Tenants by entity to tenants in common. I don't think we have tenants by entity, do we?
Tenants by the entirety. If we do, I haven't seen it in Cal. I do remember it from law school because I went to law school back in DC. So yeah, I don't want to make your head hurt, Matthew Price, but I actually don't know the answer to that off the top of my head.
But Matthew, great question to put in Probate Weekly's Facebook group, because we do have attorneys around the country. And I would start off North Carolina legal question, if you want the answer on that one, and also on the Probate Mastery group as well. Those are two good spots to put those kind of questions. Okay, so let's talk a bit about conservatorships, because it seems to me, number one, it's in the news, having gone to Stanley Moss Court in the past, about every 3 or 4 months, there was the regular Britney Spears hearing with the attendant paparazzi demonstrations, parade. I don't know what you call all that. On one hand, it's sad, the whole story and what's going on. I don't think people really understand. It should be difficult for the state to take away somebody's rights. That's not to say that she should be left to kill herself or damage herself or her kids. I'm not saying that, but I'm just saying the bar should be high in order to remove somebody's rights. But we're seeing this more and more, I think, as Americans live longer physically, but we see more and more mental declines, and I've had that in my family. So, and part of the problem is, even recently, I don't think this was your case, famously, Jay Leno went to court where his wife, I think, is in a conservatorship, right? And you would think he would have access to the finest legal help in the world. I mean, being wealthy and successful. And even he ends up going to court, in essence, to appoint a court conservatorship. So somebody somewhere along the line did plan for something, right? And I don't mean to call him out. These are complicated issues. But what are steps that we should be taking to avoid those difficult steps later? Because there's never a pleasant conservatorship matter, right?
No, there really isn't. Some more than others, or some less unpleasant than others, is a better way to put it. And by the way, so conservatorship in California, in a lot of states, I think in North Carolina, for example, I'm not sure. I think it's called a guardianship, and here a guardianship is for minors. So when I'm talking about a conservatorship, this is about, for an adult, a protective proceeding. One of the things you can do, I mean, this is relatively basic. Set up a power of attorney that's springing ahead of time. This is not foolproof, okay? But what I mean by springing is it only comes into play if 2 doctors sign off and say that someone doesn't have capacity anymore. Then you have a trusted individual, as long as the power of attorney is properly done when somebody has capacity, that can just take over things to help out without having to run the court. Right. So that, and you have a lot more control over your own destiny in that respect. And you can do the same thing with healthcare powers, in what's called an advanced healthcare directive in California, or medical power of attorney. So that's one way, is just to sort of set it out ahead of time. Separately, the California now has, and I think this is modeled in what Texas also has, something called supportive decision making. This is an emerging area in the law where somebody gets put in place to help somebody make decisions, but without taking away their rights. So it's like, hey, this person really needs help. And it sort of sets a, list of standards and rules associated with that. That's a whole emerging area of the law. That's another thing you can do short of that, is like, hey, this person really needs help. If somebody it really is a drug problem, right? So, and you want to avoid having them, committed, or put into conservatorship. We have what are called the care courts now in California. They're somewhat controversial, but basically somebody can come in and help someone that's an extremis, right, for a limited period of time with judicial oversight, in a way that, you're still in court, but it's not the same sorts of rights that are being taken away from someone in a conservatorship. And then even in a conservatorship, Not all conservatorships are the same. The court is really duty bound, and this was part of the problem, I think, in Brittany, is that not all there are certain powers that a conservatee can still have, right? And just because they may not be able to figure out how to balance a checkbook doesn't mean that they can't dress themselves or decide, where to live or stuff like that. So there's different powers that can be given or taken away if there's no other choice and you have to go to court. I always think a conservatorship is something of last resort. They're necessary sometimes, but it's last resort.
Having sat in court, with clients on conservatorship cases, it's just heartbreaking.
Yeah.
The process and the accounting, and then all the attorney's fees. I just don't know any other word than just a heartbreaking process that people go through. And I think you're right about setting up ahead of time, powers of attorney, and various other medical directives. I had a case where a client, they lived as husband and wife for like 30 years because the wife had divorced and had a settlement. So she didn't want to remarry to avoid spousal support. Comes to be, she's in the hospital, and her, kind of quasi husband, there's an insurance issue. Well, because he wasn't the husband, he didn't have access to bank records to verify the insurance payments. So they're not honoring the coverage. They're not giving her the medical care. Here she's in the hospital suffering. Whereas if she had the power of attorney for him, he'd be able to get those records. And I think one of the things I've seen in my lifetime is all these financial steps are getting harder and harder for those of us alive and well, all the more so for somebody who's incapacitated. And so I think this bodes well for your business in the future of litigation. But those of us who aren't need to prepare now, because it's not going to get easier. The banks are not going to get more customer service oriented. The insurance companies aren't going to get friendlier. They're not going to get more generous. The hospitals are not going to be more lenient in their policies. All the opposite. And so all the more reasons to. So your basic business is not doing estate plans. You have attorneys, your firms that do, but I'm saying you on a daily basis, that's not what you do. But you must, at a cocktail party or at a family picnic or something, have some cousin, nephew who's laughing, saying, "Oh, what a waste of time, all that paperwork." And I'm sure there are a couple of you just take them by the neck and scream at them, or maybe it's a child, a daughter, or a son. What do you say to people who take the advanced planning too lightly? And if you care about them, what do you say to them to help encourage them to take the proper steps ahead of time?
If you don't want someone like me making a lot of money off of your estate, take care of stuff ahead of time.
Oof. But I like you, so
maybe I'm a little nicer than that. But that's part of the message. I come from a family where there's a couple other lawyers, so that doesn't happen. I do get a lot of questions, of course, about planning stuff. But it's if people don't do it because they don't want to confront their mortality, and I totally understand that, or they don't want to pay a lawyer. I had a client, longtime client, I have a client who his email is his name at paythe2dollars.com. And his point is, if you want something done right, pay the $2, so that you don't pay $200,000 later, or your estate doesn't pay it later. That's the main point. And also, if you don't do the planning, then you don't get to control what happens with your stuff when you die. The state's going to decide. The state's going to decide that your 3 kids get everything equally, or that your spouse gets all the community property, and then there's going to be, a probate proceeding, and somebody's going to. It's just you're delaying a problem, and yes, your beneficiaries will benefit for the worldly possessions, but they will also inherit the headaches that could have been avoided with good planning.
I tell people, if you don't have a plan, follow on your own, prepared ahead of time. The state of California has one for you. It kind of looks like the DMV. It's just not as customer service oriented as the DMV. It's not as pleasant as getting your driver's license renewed in person. It's not that nice.
That's a great way to put it. Maybe I'll use that one.
Ann B asks, I believe wills are supposed to be filed with the court. Mm-hmm. And again, let's assume a California case. Are family members able to request a copy from the court because the PR has not informed them of any inheritance or not. So this would be on a probate matter separate from a trust.
Well, so
or
if it's a
will.
probate matter in California, at least, they have to give notice to all the, at least all the heirs at law. So you have to get notice of the probate, and you're entitled to get a copy, of the will through that proceeding. Now there could be a situation where a will is just a pour over will into a trust, for example, and then there won't be a probate process, and all the will is going to say is everything goes to so and so's trust, and then we go back to what I was talking about earlier, where there is a duty of the trustee to send out that notice within 60 days saying, hey, you're entitled to a copy of the trust. So long and the short of it, you should be informed one way or the other. Wills are supposed to be filed with the court. Whether or not they are, you can just get them from the court, is probably depends on the jurisdiction.
And I'm not sure if in California or not, but I will say, for example, yesterday somebody called me from San Mateo, which is famously late in their procedures, way worse than LA County. But the attorney had filed the will. It is online, and I was able to download a copy and send it to my team members. So feel free, if I can help Ann, reach out if there's a particular case. I'd be glad to help you with that. So 2 questions, true or false. Now, I'm not going to hold you this. It's on the internet, but we can blur this part out if you need be. 90% of the time, a bad estate plan is better than no estate plan at all.
90% of the time. False.
Okay.
Because a bad estate plan can lead to a lot more litigation than no estate plan sometimes.
Okay. So therefore, should somebody be very... The reason why I say that, just for business...
I know that's not the answer you're looking for, but that's the one that popped in my head.
No. I'm glad to get it, because I have to be a little more cautious now and reflect on that. The reason why there's a business side and a legal side. The legal side is, okay, obviously you know the answer, I don't. The business side is, I always feel like, well, at least they start with a plan and it's bad, then go take that to a proper attorney and get one redone. But now at least you've made some progress and you're moving, versus having nothing. You're going to go to probate court. It's going to be litigated, and there's no way out. But from a business standpoint, but I hear what you're saying, which is...
different question. I guess it's so there's a difference between a basic or, basic estate plan and a bad estate plan. When I hear bad estate plan, I hear an estate plan that causes a lot of tax problems, or an estate plan that doesn't really effectuate what the person wanted, or that, contains ambiguities in it that people are going to fight over. I mean, that is going to lead to more headaches than the DMV sort of, boilerplate rules. If you have a basic estate plan that may not be, have all the bells and whistles, but says, if you go on LegalZoom, frankly, okay, and you just say, here are my, heirs, here's what I want them to have, blah, blah, blah. There's a whole form you go through. That is better than nothing 90% of the time, at least, for sure. So,
and to take that to a proper train, get one done. And if it takes you a year or two, that's fine. But you have something. I'm sure you see this. I see all the time clients who pass where they have an estate plan in process,
right?
Very detailed, excellent, well thought. It's not executed or funded.
Sign that placeholder will, for sure. I mean, have that placeholder document, so that even if you're doing something and you want to go back and forth and whatever, but you have something in place. That is true. 90% of the time, that at least is better. So.
Okay. And then the second question is, I think this is the biggest misconception, which is, if you have a trust, you avoid litigation. Well, by definition, that's not true, because I go to your website. Well, part of a job, you do also probate litigation and other things, but so I don't know what the source of that is. In fact, I almost say the opposite, that anytime you have large assets, you're really a bullseye for litigation of some sort. The question is, how do you protect yourself or your family or your estate, right?
Right. Yeah, I'll never forget, one of the first cases I had when I started doing this type of work had a trust that was created. It was called, I think I said on it was a probate avoidance trust. Mm-hmm. And I don't know how many millions of dollars in legal fees ended up being spent over that probate avoidance trust, but they also didn't avoid probate, by the way, but that's a whole other story. But yeah, I mean, no, a trust is not going to help you avoid litigation. What a trust will do is help you avoid probate if it's done right and there's no fighting over it. Sure, a trust is definitely, at least in California, I think a lot of other states, is a more efficient vehicle for disposing of your assets than a will is. That's true.
And then the last statement I make regularly as a professional, I appreciate your feedback on, is anybody owns a house in California. Now I'm assuming, let's say $500,000, anybody owns a house or has children really has a responsibility to have at least a basic estate plan done that probably includes a trust.
Yeah, I think that's pretty good. I mean, there are devices that you now have in California. There's the revocable transfer on deft deed, right? So, there are ways where you, I guess, don't have to have one, but the answer is why not? Why not just have that will just in case, because who knows if that deed is going to be effective or not, So yes, the answer is if you own real property, you got to do some sort of planning to avoid, and that's where you get a lot of predatory stuff, by the way, where you have a house, we have one house, okay, like an estate, basically grandma had the house that's now worth $1 million because California is expensive, okay, but it hasn't been reassessed in 70 years, and it's it's being split between 6 grandkids, and there's no liquidity, right, to pay for anything. So you need to sell it, but it's going to take a while through probate. So then who comes in? The litigation finance, the probate finance people who charge a really high interest rate and make a bunch of money. And that this happens a fair amount. Actually, there's some stuff happening in the legislature right now that may change that. We'll see what happens. But so that's one example of why it's critical to have some planning in place. So yeah.
Well, so in your case, just to add some color to that, so what happens is there's 6 errors. Somebody has to hire an attorney. Somebody has to file legal fees. If there's a pushback from one of the errors, somebody's got to contest those, file the objections, answers objections, and so there's some money required. And if the only asset is the house, where you get the money from? The answer is there are companies that advance the inheritance, but it's very expensive. And so I use that as a tool in some cases, and other ones I do see it being used as a predatory tool as well. It's like any other
not
tool.
all of them are predatory. I don't mean to suggest that.
Yeah.
So there may be some people on here who, I did not mean to offend you. There are some that are predatory. And it is an important tool for sure, but the point is you can avoid all of that, or at least limit it with decent planning.
Right, 100%. Well, good. One other occurrence that came up this week was, I've never seen this before. A client went to an attorney, a private attorney, not a county. Now, maybe they were working at a pro bono seminar or something. They did a will, and they named and they had 2 or 3 children. They named as the executor of the will the county public administrator. And it was interesting because the wording in the will was the county public administrator should use all powers to streamline the process and avoid the court process. But by definition, if the county public administrator is doing the case, it almost has to go through court confirmation or in LA through the auction process. Yeah. Have you seen that? Is that a common practice? I've never seen that before.
No, actually, I haven't seen what you're describing right now. No. But yeah, that's interesting. Yeah, the auction process, I don't know if any of your viewers have enjoyed going down to probate court and dealing with overbidders in the arcane sort of process. It's always fun when I have like a new associate to bring them down to court for a hearing. I mean, it was fun before the pandemic. Now everything's remote, but
it was a lot more fun then.
Yeah,
a lot of people had energy.
And people, and I remember the first time I saw it, like, what the heck is going on? This is crazy. So yeah, no, it's an interesting process. I know that Scott G. Funk is involved in that a lot. So
That's where I met him. In fact, that was my specialty for a while, was representing investors buying those properties and kind of learning, and now I list them as well. So
Yeah.
definitely, anybody who's interested in that, that's a whole area we could talk about sometime. So
Yeah.
look, Nick, I've kept you a little bit over our time here at your hourly rate. I will get billed for a whole nother hour, so I'm gonna.
Yeah, I got a text that I got to pick up my son in half an hour. So
okay, good. And you're in Los Angeles, so that means just getting out the front door, probably half hour right there.
I can make it if I leave in the next few. But
so look, I really appreciate your time. Thank you so much for education, sharing with us. For someone to get a hold of Nicholas Van Brunt, Shepard Mullen, I'll have the contact information down below. And a big firm, but he is been just a real beacon of information and education. Thank you so much for your time. I really appreciate it.
Bill, I really enjoy these conversations. Thanks for having me.
Thanks so much.
Thanks for good questions, everybody.
And information, here's his contact information. Again, I'll put it in the chat box down below. Phone number, email, text, all that stuff. He's in LA and Century City, part of Los Angeles as well. And just a reminder, this is probateweekly.com. We do this every Thursday, 4 p.m. Pacific, 7 p.m. Eastern time, everything in between. You can register for free. We'll get your email in there. And also, if you register, we'll scroll down. You can see the past episodes, see it. You can listen to it on audio podcast, we're in all the different channels, Spotify, Apple, and all that stuff. And then lastly, continue the conversation at Probate Weekly is our Facebook group. Love to have you come on there. Post your probate-related content, as well as ask questions, look for referrals out of state, out of the area. Thank you, everybody. Thank you for all the questions and comments. Matthew Price, Ann B., Virtual Healing Space. Some really good stuff today. The Taylor Group, hope to hear from you guys later. Have a great week, and we'll talk soon. Thanks so much.